We'll say welcome all to this webinar today. I'm Claire Roake and I'm a Principal Associate in our Insurance Department. And I'm joined today by my colleague Rachel McDonnell, who's a partner and specialist in regulatory issues. And we're going to discuss the about to be implemented FCA consumer duty. And before we get going, there's just a couple of housekeeping issues. So the session's being recorded, and whilst you can see us, we cannot see you. And we're aiming to have time at the end for a Q&A session. So if you have any questions, please post them in the Q&A box at the bottom of your screen. And then these will be picked up by my colleague and senior legal advisor, Harriet Strevens, at the end. If we run out of time to deal with your question, then if you provide your contact details, we will email you afterwards. So Rachel, over to you. What is the consumer duty and what are you covering today?
Thanks very much, Claire, and thanks to everyone for joining on this, what is a beautiful sunny day, to talk about the consumer duty. The purpose of today's session is to give you an insight into the need to know elements of the duty, because across the country, firms and institutions have been working on their implementation plans over the past months or even years, and this session provides an overview for all of those who may or are likely to come into the contact with the consumer duty and need to understand how it might affect you, your clients and your business. And there's been lots and lots of rhetoric about the consumer duty being the biggest shift in financial services, but really, what is it and what does it mean on the ground? Those insurers and brokers amongst us may well be asking, sort of, why is there such a fuss in the market about this? Because is it really that big a shift that people are saying? Particularly insurance is an area that's already heavily regulated, and we already have the need, to treat customers fairly and to make sure that communications are clear, fair and not misleading. So what we're hearing a lot is, what's so different about this? And those are the issues that we're going to address as we move forward today, looking at the impact of the consumer duty and its overlap or interplay with some of the other principles.
So what exactly has led to this new consumer duty?
So for many years now, the FCA has been trying to focus on outcomes for customers as opposed to process and tick boxing exercise. And that's ultimately led to the introduction of an entirely outcome focused principle, the consumer principle, which you can see at the top of the slide there. A firm must act to deliver good outcomes for retail customers. And that is, a key aim of which is to develop those, to deliver those better outcomes for customers and ensure protection from harm in our retail financial markets.
I mean, that's familiar to most of us, but how are the FCA envisaging that this will be implemented and what's going to change?
So the duty is looking to reinforce and complement the FCA's existing handbook requirements. And there are three parts to the duty. That's the new consumer principle. There are three cross-cutting rules which establish key principles that must underpin a firm's conduct. You can see those on the slide there. Must act in good faith towards retail customers, avoid causing foreseeable harm to retail customers, and enable and support retail customers to pursue their financial objectives.
So are we only talking about retail customers?
Yeah, that's right. It does only impact on retail customers, but depending on the area in which you work within that regulated sector, then the definition of retail customers may well be slightly broader than you might think. And so underneath those three cross-cutting rules, you can see also 4 outcomes on the slide there. And now the duty comes into force on the 31st of July this year, so next month, for new and existing products or services that are open to sale or renewal. And given the proximity of its rollout and the impact that it might have on those insurers or brokers, it's definitely something that everybody needs to be keeping in mind. And then separately, in a year later, on the 31st of July 2024, the duty comes into force for closed products or services.
So before you move on, Rachel, what is a closed product or service?
Well, closed products are those products that are no longer marketed or distributed, and they're not open to renewal. If existing customers can continue to make payments, that would still be considered closed if the product or service is not open to new customers. So those are the closed products where the duty comes into force next year.
So when does the duty apply?
The duty applies to products and services offered to retail customers and to all firms who determine or have a material influence over customer outcomes. So what's really important here, particularly given the distribution chain and often quite complex distribution chains in insurance, that it's not just applying to those with a direct customer relationship. It's applying to anyone within that chain that might have a material influence over customer outcomes. As an aside, it's also introduced an obligation, the FCA has also introduced an obligation to notify the FCA of breaches or suspected breaches of the consumer duty within its distribution chain. So you are going to have a situation where other firms within your distribution chain are thinking about whether you yourself are complying, because there is an obligation on them to notify the FCA of suspected breaches. The duty, in terms of the definition of what a retail customer is, it tracks the definition used in the various FCA handbook chapters. So firms that are subject to ICOB's, the Insurance Conduct of Business Sourcebook, which I expect is many of you joining today, a retail customer includes a policyholder or a prospective policyholder, and it can include some commercial customers, such as some SMEs.
How does the duty define the prospective policyholder?
Yeah, so that would encompass anything that happens sort of before pre-binding.
And in the insurance context, when doesn't the duty apply?
It won't apply to reinsurance or to contracts of large risk sold to commercial customers in the UK.
Do you have an example of the type of contracts described as large risk?
Yeah, large risk is defined, it tracks the definition in the Insurance Conduct of Business Sourcebook. So it's a fairly complex definition included within it, but it does cover categories of risk such as railway, rolling stock, aircrafts and ships, among a number of others.
So are there other situations in which the duty doesn't apply?
Yeah, so there's the contracts of large risks, and then there's contracts of large risk who sold to anyone, not just commercial customers, where the risk is outside of the UK. And it also doesn't apply to activities connected to the distribution of group insurance policies or the extension of those policies to new members. So there we're looking at things like workplace group life insurance policies.
So moving on, what does all this mean for individuals within regulated firms?
Well, all senior managers within regulated firms will be responsible for ensuring that the business of the firm complies with the requirements of the consumer duty on an ongoing basis. And in addition, the FCA is going to be amending the individual conduct rules in its Code of Conduct Sourcebook and adding a new rule, making sure or requiring all those members of conduct rules staff who deal with activities that fall within the scope of the duty to ensure they're alive to the need to act to deliver good outcomes for retail customers.
That sounds like a big ask. Is the consumer duty going to lead to a complete change in culture?
I mean, I think that's the FCA's hope, that we're going to start thinking more about outcomes as opposed to process and tick boxes. And what it does mean is that firms are going to need to plan for training of all their staff subject to the rules and to explain the additional rule and its implications. Certainly the aim is to embed good culture by making sure that everyone understands they have a part to play.
You mentioned at the beginning that you'd be looking at the concept of treating customers fairly. Just how will the new consumer duty affect the existing obligations that are imposed on the industry to treat their customers fairly, or is that something that won't change?
So you can see the FCA principles for businesses up on the slide there, Principle 6 and Principle 7, which should be familiar to many of you. Put simply, Principle 6 and 7 will not apply where the consumer duty does, but where the consumer duty doesn't apply, Principles 6 and 7 will apply. So I think this of course creates some additional complexity in the handbook, as you have several principles which, at least on the face of it, overlap with each other, although many of us will think that's not necessarily something new. There is some suggestion by the FCA that they will over time look to simplify some of those complexities, but it remains to be seen how that will be done.
So will customers have a right to claim for any breaches of the consumer duty?
Well, strictly speaking, no, not a direct ability to claim for breaches. But what's really interesting here, I think, is that it remains to be seen how the consumer duty might affect the standard imposed by the courts in, for example, negligence actions. Plus, customers will be able to complain to the FOS.
So the consumer duty is focused upon client outcomes being protected. Now, as you say, consumers can, of course, always complain to the FOS, but it already has backlogs of complaints. Do you think the FCA has missed an opportunity to introduce greater protection for the consumer by allowing them to claim for a breach?
Yeah, I think that's an interesting question. It's definitely something that was really grappled with, and there was a lot of strong feeling about whether there should be a direct ability to claim for breach during that consultation process, with it ultimately deciding that they couldn't. So breaking it down, currently Section 138D of FSMA allows the FCA to decide whether individuals should have a personal right of action, so an ability to claim under each of its rules. And they would then be able to claim directly from the firm any losses suffered. So that isn't going to be the case here with the consumer duty. But I do think, at least in the wider industry, is that the impact is likely to be felt elsewhere in any case. So, for example, as I said, in negligence actions, there may well be enhanced consumer protection and increased expectations in the financial services sector because of the consumer duty. And so where a duty of care is found, the standard of that duty may well be higher because the consumer duty may be thought to be effectively creating that higher industry standard overall. So then you're looking at, well, what is reasonable care in a negligence claim? Well, you might be saying that's higher now because look at the consumer duty. It remains to be seen whether that will play out in the courts or not.
So what about the contractual position for breach of statutory duty? How do you see that being affected?
Well, in theory, it may well have a similar effect. So typically you're looking at sort of failure to perform services with reasonable care and skill. And so again, when you're thinking about the question of reasonable care and skill, what is that? And how does the consumer duty impact what's reasonable now? And what I can tell you is, for someone that acts on both sides of the fence as claimant and defendant, I'm in no doubt that the consumer duty is going to be used on a regular basis to support claims. Even if it's just a throwaway line reminding firms of their obligations, just because it isn't directly actionable doesn't mean that people aren't going to try and use it in any way they can.
And how might it affect complaints at the FOS?
So the FCA has stressed a number of times that it is working with the FOS to ensure there's consistency about how they make decisions in terms of the consumer duty. I think everybody, who comes into contact with the FOS will appreciate that the FCA and the FOS have really different roles and operate on different platforms. And the FOS decides cases on what is fair and reasonable in all the circumstances. And it's going to be considering that consumer duty in its decisions. And, in terms of what the consumer duty means, well, this is likely that sort of uncertainty is going to continue, particularly in circumstances where it's unlikely that there's going to be any judicial interpretation on the consumer duty to help the FOS, at least initially anyway.
So let's move on to consider some specific insurance considerations. Do you think this new duty is going to have a knock-on effect for professional indemnity insurance?
Well, it's possible insurers that provide professional indemnity cover will want to understand the impact on claims handling and complaints, and in particular, the outcome of those complaints, as this is going to affect the nature of the risk they're covering. But that is a sort of knock-on effect, I suppose, from the consumer duty implementation.
So given the need under this new regime to focus upon adverse outcomes for the consumer, it seems to me that both insurers and SMEs, and the SMEs they insure, are going to have to look very carefully at their policy wordings and contractual terms and conditions and consider how they might need to change. Is that something you agree with?
Yeah, I think I do. I mean, I think looking at the insured and potential insured firms, they're going to be needing to demonstrate, or at least able to demonstrate to the FCA if asked, and therefore, their insurers as well, that they fully understand the implications of the duty and the changes required that would include, and that would include their contractual terms and how these already impact on their customers. In that vein, it's going to be interesting to understand the FOS's approach to the duty, and if you suddenly get an increase in awards by the FOS because of the new duty, and then that will then obviously have an impact.
So leaving aside the actual wording of policies and contracts for a moment, what sorts of checks and balances do we envisage will be needed? Firms and insurers already record telephone discussions or insist that purchasers watch videos or listen to recorded messages before deciding to buy products. But of course, that doesn't mean the consumer actually understands what they're listening to. How is compliance with the duty going to be monitored? I mean, I'm assuming it's going to be very fact specific.
Claire, that's a really big question and a big answer, and definitely something that firms have been grappling with for the past 12 months or even longer. The FCA does appreciate, and has said that it appreciates, that particularly when dealing with lower value products, it's not proportionate to be fact specific in relation to each individual case. And that's part of the drive for firms to take a data-led approach. So in those circumstances, looking for themes where it's not proportionate to look at individual circumstances. But there's been work ongoing in all areas of the business to make sure they're ready to implement the consumer duty from the end of next month.
And what impact might there be on the claims handling process?
The FCA, in relation to claims handling, the FCA has said that it has commented that it should be as easy to make a claim as it is to take out the policy in the first place. But I do appreciate that sounds a little naive.
Yeah, I agree, because not least as both and often on both are often not straightforward on any level.
Yeah, exactly. And I think to give comfort, the FCA aren't saying that they specifically have come out and said that they're not saying that all claims must be accepted or that extensive reasoning must be provided where claims are rejected or declined. But it will be important to ensure that reasoned decisions have been reached and that those are demonstrable to the FCA if asked. The FCA have acknowledged and considered that really often that the experience of making a claim may well be in the insurance sector when a product's value and service are really put to the test. And just to give you some more background on some of the things that the FCA has said that that they think need to be addressed in this area, they talk about sludge practices, and that's put simply a practice which unreasonably restricts a customer or prevents a customer from taking certain actions. So that's something that can be done intentionally. So that, for example, putting in barriers that make it difficult to claim or complain, or unintentional, which could be caused by firms failing to have the right systems and controls in place or monitoring practices. The FCA actually gives a good example of a claims handling process requiring customers to provide hard copies of all evidence and not adequately considering a request from customers to waive that requirement. So that's a good example, making it more difficult for customers to bring a claim because they've got to provide hard copies of documents, and then not really considering when customers say that might be a bit difficult.
It strikes me that this may well lead to even more surveys being thrust at consumers when they're trying to carry out what are often quite simple financial transactions. So what's your view?
Yeah, I think the reality is that there may well be more surveys and there may be more sort of testing in advance of product launches, for example. But in addition to that, you're going to have more monitoring and data review and looking at numbers of claims and rejections and complaints to try and find out, to try and, you know, get as much as you can out of the information you're collecting in any event, and considering it from a consumer outcomes perspective as opposed to other different types of perspectives. So, for example, you know, high numbers of rejected claims may well indicate an issue with a particular product.
So what's next? What can we and our clients expect in the not too distant future?
So to begin with, we are all facing a very tight timeline, the implementation to be by the end of next month, and everyone affected really should have been acting well before now, but certainly must act now, because the FCA will undoubtedly be checking, and there are going to be repercussions. And as you often see with, you know, big shifts and big new introduction of new areas, the FCA has been monitoring implementation over the last few months and also giving speeches about the new consumer duty. And you can see on the slide there on the 10th of May, so last month, Sheldon Mills, the Executive Director of Consumers and Competition, gave a speech making clear that the FCA is going to prioritise the most serious breaches and act swiftly and assertively where it finds evidence of harm. And I thought it was interesting the second quote there about taking robust action such as interventions or investigations along with possible disciplinary sanctions. And I think what they're signalling here that, you know, enforcement actions and the like can be quite drawn out processes. But what they're saying here, I think, is if they are finding that firms haven't been implementing the duty correctly and there's evidence of harm, then they will intervene at an earlier stage, which is something they have been doing in more recent years.
Well, thank you very much, Rachel, for taking us through what is a very significant change about to impact the insurance and many other industries. I think we have time for one or two questions. So, Harriet, over to you.
Thank you very much. I'll not be too long with these, as I note the time is moving. Rachel, if I might ask a question which has come out from the audience, and it's this. Some firms have been preparing for the consumer duty for months. Well, that's all very well for big banks and insurers, but smaller firms may not well have the resources to spend so much time and money on implementation. What are they supposed to do?
I think that's something that the FCA does appreciate. It always has appreciated the need to take a proportionate approach depending on the size and the scale of the firm in question. But the key thing to remember is that if the duty's applying to your firm, just because you're small doesn't mean you don't need to do anything about it. It just means you need to take, you need to take a more proportionate approach to it. And there is quite a lot of guidance on the FCA website, quite useful guidance and podcasts and lots of information that the FCA has put out about the steps that firms need to be thinking about. And a lot of that is driven to those sort of more smaller firms, so it could be really useful.
Thank you. I mean, Claire, do you think that the level of incurred costs is likely to rise with the introduction of the imposed duty? I mean, for example, the time taken to investigate whether or not there has been compliance, let alone, of course, further time proving it.
I mean, the context of the work that I do, defending professional negligence claims against financial professionals, I think the short answer has to be yes. The consumer duty probably will increase costs. I mean, just navigating the existing FCA rules and regulations is never straightforward. So I think anything that adds an additional layer is likely to cause extra work and inevitably, along with that, extra cost.
Yes, I see that. Well, we could go on talking about this for some time yet, but I'm conscious that time is running on. So I'm going to pass the baton back to you, Claire, if I may, to wind up.
Thank you, Harriet. So that brings us to the conclusion for this morning. I'd like to thank you all for joining and Rachel for also joining us today. Please do complete the feedback form, which will be on your screens when we sign off. And you'll also be sent a copy of the recording of this session. And if you have asked a question that we haven't had time to address today, then we'll also be in touch about that. We hope you'll attend our next session, which is on Thursday, the 13th of July at 11 o'clock. In that, we're going to be considering the impact and consequences for both insured and insurers of being underinsured. We hope you'll be able to join us for that session as well, but thank you for joining us today, and we wish you all the rest of a good day.